Hi everyone and welcome to today's Phil Fisher webinar. I'm Flick and I'm joined today by my fantastic colleagues Natalie and Pardeep, and we are all European privacy specialists based out here in Phil Fisher's Silicon Valley office. So we wanted to put together this webinar because there has been an absolute tsunami of emerging privacy requirements. It feels like European data protection law is the gift that just keeps giving to lawyers like myself and the rest of us on the team, because we keep getting case law guidance. It literally is hitting us on a daily basis. And we're noticing that it's creating a lot of noise out there that is making it quite difficult for our clients and other privacy practitioners to kind of weed through that noise and figure out where they should be prioritizing their compliance efforts. We know, particularly at the moment, a lot of people are dealing with tighter budgets. We've got, resource-strapped teams. And so we've given some thought to thinking about, well, with all of that going on, where could we be really focusing our efforts when it comes to dealing with all these new and emerging requirements? So to kickstart things, my colleague Pardeep is going to give us a bit of an overview of lots of the different laws that you might have heard about, and kind of give you some guidance on really what we should be focusing on, given there's so much law out there. Pardeep, kick things off.
Thank you so much, Flick. So like as Flick mentioned, there's a huge amount of new European privacy laws which are currently making their way through the European legislative framework. Keeping track of all this law, cybersecurity, AI law, data protection laws can be really difficult. So you really need to identify which laws are important to your business, which pressing compliance requirements you need to comply with, whether there are any high-risk areas that you need to focus on, and really make sure that you're prepared before any of these laws come into effect. So on this slide, we provide a timeline from 2020, which summarizes the current status of the key incoming laws. So in the blue, we have when the law was proposed. In orange is when it was adopted, or when we think it will be adopted. And in green, when the law will apply. You will see that some of these laws have already been adopted and others have some time to go. So the laws that we think that you really need to focus on right now and should be an immediate priority for your business is the DSA, the Digital Services Act, which was entered into force at the end of last year in November 2022, and it will become applicable to businesses from next year in February 2024. The DSA aims to protect users by making it easier for them to flag hate speech, terrorist propaganda, and other illegal content. It updates the liability regime for digital service providers and creates new takedown, transparency, and reporting obligations. Another law that recently was adopted is the Data Governance Act in June 2022, and it will apply from this year in September 2023. The DGA is part of the European Strategy for Data and aims to increase trust in the voluntary sharing of data for the benefit of both businesses and individuals. It will also make data more available and facilitate data sharing across EU member states and other sectors. Another law which recently entered into force is the Digital Markets Act in November 2022. And this became applicable to businesses 6 months later, actually, this month. The DMA defines when large online platforms qualify as gatekeepers, which are when firms offer core platform services such as social networks, search engines, and video sharing platforms, which meet defined turnover and user base thresholds. It places big obligations on gatekeeper firms and sets up prohibitions on certain conduct. Another law which your business should prioritize right now is the NIS2 directive, which entered into force in January 2023, and each EU member state must adopt and apply the requirements by October 2024. The aim of this directive is to enhance the overall level of cybersecurity in the EU, and it replaces and repeals the existing NIS1 directive by applying a much wider range of sectors and introduces more strict enforcement measures. It's also important to note that the NIS2 is not just about personal data, it also covers security of the services and non-personal data. Also, our colleagues here in Silicon Valley are doing a webinar in early June, so definitely watch out for that. You will see in the timeline there are some other laws which are currently going through the process, and they're not really that much of an immediate priority right now. These include the AI Act, which has been going through the process since April 2021. There are some issues that still remain open, including specification of prohibited AI use cases and the classification of high-risk AI systems. We have a webinar coming up on AI governance in late June, early July.
And just to say, there's a huge amount of chatter about AI at the moment, and you might have seen lots of information being pushed out by law firms and others about the AI Act. And we're not kind of saying it's to be ignored, but just a quick reminder, when you've got a lot of different shifting priorities at the moment, or lots of information being chucked at you, just to let you know that the AI Act is still not yet finalised. It's not final law at the moment. We're expecting that to be finalised this year, with a kind of 2-year time frame for people to get ready to be compliant with it. So we're really talking about 2025 until the AI Act really hits and becomes applicable for companies on its current trajectory. Now, there are some important changes that it will introduce, definitely not something to ignore, but keep an eye on it, not something you need to action, I think, right now.
There's also some other laws which are currently going through the process, so they're not really that much of a priority. These include the Cybersecurity Resilience Act, the Data Act, and the e-privacy regulation, which was proposed all the way in January 2017. So that is taking a really long time right now. It was intended to sit aside the GDPR in 2018, but it hasn't happened yet. So overall, the main laws that your business should prioritize are the DSA, DGA, DMA, and the NIS2 directive.
And some of those, some of those have different applicability. So the DMA is really only relevant if you're a large platform, but the DSA, for example, has got provisions that apply if you're, for example, a hosting service provider. You're going to have to comply with some of the requirements there. And we've done a huge round of webinars and pushed a lot of content out about the DSA through some of our other colleagues. So we'll make sure to link through to some of those webinars in the notes when we post this.
And actually, that's a nice segue onto our one of our future topics on mapping, because in order to understand whether any of this applies, you'll need to map your data and understand what you're doing and whether any of these laws are things that you need to have on your radar.
Yeah, absolutely. And look, we couldn't do a webinar this week without talking about data transfers. And I put a picture of a Whopper burger on there because the headline grabbing news is that Meta this week has been fined an absolutely whopping 1.2 billion euros there by the Irish Data Protection Commissioner, so the Irish regulator. And we've been waiting for this decision to come out for a while. And we thought it would just be helpful to give you a little bit of a primer on what it means for people and some of the core kind of facts. So they've imposed a fine, and basically Meta Ireland has been ordered to suspend future transfers of personal data to the US. And they've also been ordered to delete the personal data of their European users that they've already transferred. And all of that's got to be done within 6 months. So in addition to the fine, we've got various stop orders here, which on paper looks like it's going to be pretty fatal for Meta unless they can switch over to a different transfer mechanism. Now, this decision, I think it's really important to flag what this decision does not do. It does not say that data transfers to the US are banned, but there is not a ban on European to US data transfers. There's also no ban on the use of standard contractual clauses. So you may remember there was a case back in 2020 through the Europe's highest court, the CJEU, which basically invalidated the current EU-US privacy shield. And as part of that decision, they reinforced the fact that standard contractual clauses remained a valid data transfer mechanism, but laid on some additional requirements, one being that parties who were looking to rely on them now need to carry out effectively a transfer impact assessment to test whether or not, in addition to the standard contractual clauses, whether they need to layer on any additional supplementary measures to make sure that the data remains protected to European standards. And so what this case was looking at was whether or not Meta, in using the standard contractual clauses and taking into account the supplementary measures that they had applied to try and protect the data, whether or not they had protected that data to European standards. And the courts felt, for a number of reasons, principally focused around the fact that the data was still subject to these egregious, or what the courts feel are egregious, US foreign surveillance laws, that taking into account all the technical measures that have been applied, Meta just hadn't met that required standard for protecting European data. And so they couldn't, in those circumstances, rely on the standard contractual clauses. So we're not saying everybody has to stop using the standard contractual clauses. What this decision reminds everybody is that we need to do more than just sign the clauses. We need to really do those transfer impact assessments to make sure we are looking into and assessing whether and what additional mechanisms or safeguards we need to layer on to ensure that that data is protected to European standards. And unfortunately, what that case does is set an incredibly difficult bar there to meet, to be able to make that transfer work if you're trying to make transfers to the US, because they've essentially reinforced and reminded everyone that US law does not provide an essentially equivalent level of protection to European data protection law. And they're effectively saying that unless you can, encrypt the data and ensure that no data is processed in the clear in the US, that there are going to be no real additional measures that you can layer on to make that transfer work. So we've effectively seen an application of the very conservative guidance the European Data Protection Board had already published and had started to be reflected in case law coming out of places like Germany, where we had decisions against people trying to use Google Analytics, and the Austrian regulators. So it doesn't really change the legal position that we've all been having to work with for a while. It doesn't create any new law, but it just reminds everyone that we really do have to do a lot more to be able to make our compliance narrative work if we're trying to do transfers of European data up to the US. So we can still use standard contractual clauses, but as a practical outcome of this, everybody's going to have to be making sure that they've documented and assessed the risks of the transfer to the US and elsewhere. So this, the logic, all of this applies to any transfer that you're doing internationally. And then the other thing I think that's just worth flagging here quickly is that there's a lot of talk about the new transatlantic data privacy framework. So this is going to replace the current Privacy Shield framework. And it's kind of, almost now being seen as the potential knight in shining armor for Meta, because we know they have 6 months to try and fix this issue. They won't be able to fix it unless this data privacy framework can be agreed in the meantime and provide an alternative mechanism upon which they and many other US companies could lean on to affect their transfers to the US. So off the back of this decision, everybody was eagerly kind of then turning to the European Commission to kind of see what they would say about it, because we're waiting on them to agree this data or confirm that they deem the data privacy framework adequate. And the European Commission spokesperson has come out and said they expect this to be fully functional by the summer. So there is therefore a glimmer of hope that we may have an alternative adequacy framework there to rely on in addition to the standard contractual clauses, which I think is going to be incredibly helpful. But it's just to add this to your kind of compliance priorities as you start to look ahead over the next few months, because if you want to rely on that data privacy framework, there's going to be some work to do to be able to comply with the principles that you will be required to self-certify to. So I'd add it to your list of things to look into if you're trying to manage a lot of these data transfer compliance issues to the US, data transfers to the US. And we'll see also that all of this chat around data transfers, it also feeds into some other issues which we're going to talk about today, and other priorities that we suggest you kind of focus on in the next few months. And I should also say our colleagues have done a fantastic webinar that was recorded on the 25th of May which goes into a lot more detail about the details of that case and the practical implications for people. There's also a fantastic blog that you can find on the Field Fisher site about that case. So Next priority that we think you should have up there, and I appreciate this is not everyone's favourite topic, is one that potentially if you were at a dinner party, people would be leaving very quickly if you brought this up, but data mapping. So data mapping remains one of these exercises that is really critical to being able to properly build out your data privacy programme. Now, just a reminder, the GDPR itself doesn't say you have to do data mapping. There's no provision or in the regulation that mandates that you do a data mapping exercise. But there are certain obligations in the GDPR that just can't be met properly unless you know what data you are processing. And so naturally that means that you end up having to do some data mapping or data inventory exercise to be able to properly address those obligations. So it's a really foundational aspect of any privacy program. It gates a number of other compliance obligations or gates your ability to be able to address those obligations. And so it's really just a reminder to organisations not to forget that data mapping needs to be done. Sometimes it can be hard to get the business to buy in, to engage with the data mapping process because it's complex, it takes time, but it is absolutely critical to being able to address a number of obligations. And importantly, when, you know, not just the GDPR, but actually a number of other privacy compliance requirements around the world can't be met unless you understand what data you have, what you're using it for. It's really a data mapping exercise is all about addressing the 5 W's, which we've got up on that, you know, picture. Where are you processing data? Why? How? Who are you sharing it with? And having that knowledge is really critical. So just to give you an idea of how you can kind of build up your internal kind of momentum or to try and get some buy-in to this. So it's really necessary to a number of compliance obligations. One being, we know you've got to maintain records of processing under the GDPR. So you can't populate those records again unless you've done some kind of data mapping exercise. Importantly also, and relevant to the topic I just mentioned, data transfers. One of the things we know that the regulator has kind of guided people to do is to understand their data transfers. Where are you moving data? Who are those third-party recipients? Where are they based? What types of data? What purposes? What protections are they going to apply to that data when it's transferred to those locations? So doing a data mapping exercise can really help you understand and answer all of those questions so you can start to dig into your data transfer compliance. It's also going to be pretty critical to being able to respond to data subject rights, maintaining an accurate privacy notice, and also completing those data privacy impact assessments that we know have to be done if you're doing things like high-risk processing. So practically speaking, how do we then go about this data mapping exercise? We know it's important, but we also know it can be difficult to get those projects going. So I would encourage everyone to, you know, think about starting small initially. So maybe it's that you begin with a single department, a single product or a process before you start expanding to others. So it'll give you a chance to kind of refine your process, test out who the key stakeholders are, and start to develop a process for doing that data mapping exercise that you can then roll out as part of a bigger project. So it can be overwhelming to try and map every single thing that's going on in the business. So let's start with the critical areas. Let's start, for example, with understanding what you're doing with your products, which can then feed into building out your, you know, outward-facing compliance, which is obviously very important. The window dressing piece is important to your overall risk profile. So it doesn't have to start big. We could start small just to take this in bite-sized chunks. And then importantly, there's quite a bit of technology out there that is now being kind of pushed out into the market by various vendors to help people with doing data mapping exercises in a more automated way. Now, a spreadsheet exercise, you can get away with it. You can do data mapping with a spreadsheet. We often do it that way for clients with a more manual exercise. Sometimes it's the only way that it can be done in a kind of manageable way for people. But I think if you can start to develop a more sophisticated way of doing it through the use of different technology tools, that can lead to a more comprehensive mapping exercise, and one that is easier to maintain over time. And then we need to get stakeholder buy-in for this. This isn't something that can be done alone by a lawyer or a DPO. It's something that's going to require cross-functional input from different parts of your business so that you can gather the information that you need to properly do this mapping exercise. We could talk a whole webinar about how to practically do this, but the key takeaway is just to remind people not to forget this exercise. It's going to feed into so much of your privacy program and enable you to kind of set a better foundation for that program. So Natalie, over to you. What's the next priority we should be thinking about?
Thanks, Flick. The next topic we wanted to talk about was contract refresh. Now, I think this is going to make a lot of people groan because we've been through a couple of years of re-examination of contracts, particularly for the purpose of updating them to include the new SECs. But we do think it's, if you're thinking about where to allocate resource and prioritizing management of risk from a privacy perspective, after you've mapped data, after you've understood what new laws are coming down the road that could affect you, we think contract refreshes is where to focus your energies. So all these laws can give rise to specific contractual requirements. Think about Article 28, annual DPA terms, the need for SECs. But new laws can also give rise to a flowing down of contractual obligations that will allow stakeholders to comply with direct obligations on them or manage liability associated with the increased legal risk that comes from complying with the sort of tsunami, as Flick put it, of new legislation. So we've heard about all of the new laws out there, and we're becoming increasingly aware of related risks associated with artificial intelligence, machine learning, the drive in the market to improve products using data being a fuel for so much technological advancement that can go on. And with all of this in mind, we're advocating this re-examination of contracts in the coming months, or could be the end of the year or the beginning of next year, in an attempt to manage some of this legal risk. Not everything that I mentioned today is going to apply to every business out there, but depending on where you sit in a particular ecosystem or supply chain, you may be coming under increased pressure to accept novel contract terms, and you'll need to start to think about where you're going to draw the lines for yourself and your business to manage the risk. And so this is why we think an allocation of resource in this area is going to be valuable. So we can't cover everything that is likely to impact privacy contract drafting in the time we have, but to give you a flavour of what's on our radar, we're going to start with data transfers. Again, I know we've heard a lot about them already, and we're all exhausted by data transfers at this point. Most of us have gone through an SECs update for the European Commission SECs, and some of us will have already started to update our contracts for UK purposes. And just to let you know, if you haven't updated to include the European Commission SECs in your contracts, that deadline has passed, so you should have migrated onto new SECs by now. But the UK regulator has greenlit reliance on the old standard contractual clauses, the European Commission standard contractual clauses, for a little bit longer. So you have until March next year to bring contracts up to date for UK purposes. After this date, you'll need to be on EU SECs accompanied by the UK addendum, or you'll need to use the UK International Data Transfer Agreement for transfers from the UK too. So there is still a little bit of work potentially for some out there to get up to date with the latest data transfer provisions. If you've combined your EU and UK contract updates for transfer purposes, you might be feeling rather smug and that you're all set for transfers. But as Flick mentioned, we now have this decision of the Irish Data Protection Commissioner against Meta, which I think is going to get people a little bit more interested in certification under the new data privacy framework, because after all, the framework will be the only guaranteed legal solution, for as long as it is not invalidated by another court decision, for transferring data from the EU to the US. So while all of the efforts with respect to SECs were vital, given the gap that the invalidation of the Privacy Shield left, it could be in order to have a very robust set of measures in place that you might want to certify under the new framework, as well as having SECs in place as your fallback. And unfortunately, certification of the framework will bring with it the need to re-examine your contracts to ensure that you're flowing down framework principles to vendors, for example, and making sure that you've put the principles within your contractual requirements so that you're actually compliant with the certification that you're making under the framework. So going forward, in light of the sort of ongoing data transfer saga, as I said, the most robust option may be to re-examine, to consider certification under the framework, to still have in place those SECs, but update your contracts to allow you to comply with framework principles. Moving on from data transfers, Pardeep mentioned at the beginning of our webinar today NIST 2, which brings a larger number of businesses within the scope of its obligations. So, for example, there'll be an increased number of digital providers, such as online marketplaces, search engines, social network platforms, and digital infrastructure providers, such as public electronic communication networks and services, cloud service providers, and data centers. So we really are pulling into NIST 2 a much broader set of businesses than the current NIST directive and national legislation applies to. And importantly, for a contract update, NIST 2 imposes, among other things, strict reporting of security incidents with initial flagging of any security incidents needing to take place within 24 hours. So this will inevitably interact and overlap with GDPR breach reporting requirements that you may have already agreed contractually with service providers and customers. And it's going to be more difficult if you are caught by NIST 2 to rely on the more flexible without undue delay standard for breach reporting. So if you are caught, and this goes sort of ties in everything here, if you think you might be caught by NIST 2 and you've done your mapping and you understand where your obligations lie, it's another thing to open up the contracts to comply with, because you'll need to think about how you manage things like breach reporting and the stricter requirements that new legislation like NIST 2 may bring. Moving on to artificial intelligence and machine learning. So, as has been mentioned already on this webinar, there is a lot of noise at the moment in connection with AI, machine learning, and the use of data really for product improvement purposes. They bring a lot of privacy issues. The technologies themselves are novel and therefore potentially high risk. And that's something that we know from a GDPR perspective needs to be scrutinized. We can't, again, tackle the entire topic, but you can check out a recent webinar that Phil Fisher did on generative AI, which is on the Silicon Valley Phil Fisher YouTube channel. We're focusing on contract for now, though, and I think the main takeaway here is that new technology may mean rethinking the contractual approach. It's going to be vital for both vendors of services that integrate artificial intelligence or machine learning, but also for customers who want to take advantage of the new technological opportunities to manage the risk associated with onboarding them. So what do we need to rethink? Well, first, I think we might need to re-examine our permitted purposes. So AI and machine learning need data, but your average vendor contract is likely to be limited, such that customer data can only be processed for narrow and specific purposes that are related to the delivery of the vendor's service. In order to make some room for artificial intelligence and machine learning and other service improvements generally, vendors are going to want to ensure that that use case is permitted, or at least not contractually prohibited. In some cases, customers may need to prohibit such data use. Customers have to ask themselves, to what extent can I allow my data to be used to improve a vendor's service? The give to get model, which effectively means the more you give into the service, the more you get out by way of product improvement, just might not work because you have upstream restrictions which prevent you from flowing down data for a broader use case, or it could be that the sensitivity of your data precludes you from allowing further use as a matter of law or liability risk. And this goes back to mapping again. So, I mean, just to hammer home the mapping value that Flick's already highlighted, unless you understand what your upstream and downstream obligations are, and unless you understand how sensitive the data is that you've onboarded, it'll be difficult to manage these risks properly. So ultimately, we're moving into a world where artificial intelligence and machine learning are going to be pervasive. We've already seen it. So many businesses are now able to integrate these amazing technologies to increase the efficiency of the services that they deliver. So it's a good time now to try and decide for your business where the limits and opportunities lie, so that you can set your contracts up for success. And that is going to be a shift in the way that you approach the contracting process. It's really nice, I think, to be able to just say, no, we're not going to do any of it. But I think the reality is that we might have to engage with these broader use cases as we all try and take advantage of the opportunities these new technologies bring. There could be prohibitions on use, there could be opt-outs for service improvement for certain customers, but ultimately it just requires some thought. There's going to be a balancing here. Related to this is a question around classification of stakeholders. So from a GDPR perspective, we have the roles of controller and processor, and they may need to be rethought. If you're using data for product improvement, including machine learning or artificial intelligence, you'll often be a data controller, but not always. And as with all controller and processor analysis, it's a factual assessment. Once you've undertaken the analysis, something that will again be aided hugely by data mapping, you'll be able to determine what your posture is, your controller and processor roles, and then contract accordingly. And as you'll probably know already, it's a very different contracting approach if you fall into a processor role versus a controller role. Some vendors may have contracted exclusively as data processors up until this point and want now to re-examine the approach, because failing to consider the possibility of a controller role could result in a contractual breach. The controller role is likely to cut across permitted use provisions that are commonly built into DPAs or data processing agreements, and by undertaking a controller role, you may find you've fallen foul of the agreements that you've put in place because you haven't quite built yourself in enough flexibility. Finally, I just wanted to mention AI governance. So as we talked about at the very beginning of the webinar, AI legislation is a little way off. We do have the AI Act working its way through the European legislative process, but already we've got overlapping commercial and privacy law principles that do require attention, and both AI governance and heightened privacy compliance awareness needs to be baked into the contractual approach, notwithstanding that we don't have a comprehensive AI law yet. In this respect, there are various questions that developers and implementers of AI or machine learning technologies need to be asking themselves, including, does the technology undertake automated decisions? Are the models free from bias? Do they work consistently as intended? Are the models explainable? Can you understand what data inputs are needed for the technology to work? And what are the data outputs? Are those outputs personal data? Again, another nod for mapping here. Has the technology been built in a way which allows for data subject rights to be effectively exercised? And all of these things need to be re-examined in the AI and machine learning context. And the answers to these questions will inform the way that you approach your contracting. You may find that assurances need to be sought around the explainability of AI and the accuracy and appropriateness of any decision making, and you may be being pushed to give guarantees that models are free from bias or do not give rise to discriminatory outcomes. These sorts of contractual provisions probably were not on anyone's radar a few years ago, but now rightly they will be. And as a vendor, you may be coming under more pressure to give those guarantees, and you may need to be giving your customers more assurances around the way that your technologies work. The additional scrutiny that will be warranted in connection with clauses governing access to information and systems for audit purposes may also be relevant. So if you need to ensure that the way that your technologies are working satisfies your customers' requirements, they may try and shortcut this by saying that they need additional audit rights. And you can also expect there to be more focus in connection with any terms dealing with cooperation and assistance, whether that's in relation to data subject rights or for the completion of DPIAs. These are two areas which we think will come under a lot of pressure from a contractual perspective as customers need more information to be able to satisfy their own GDPR obligations. Finally, and hopefully to tie it all together a little bit, I just wanted to mention liability management. So managing liability in connection with data risks, data protection risks is never easy. And the approach has to be calibrated depending on the type and size of the risk, the nature of the processing, and also the value of the contract. But the new laws, requirements, and technologies that we've mentioned today may signal that it's time to take a look at the provisions that you have in place and consider whether they need to be refreshed. In particular, revising liability management clauses probably needs to take into account the transfers to high-risk jurisdictions that are going on, particularly given the question mark that remains around the ability to fully mitigate risks, in particular with respect to transfers to the US, as we've mentioned, the use of novel technologies such as artificial intelligence, and the controller processor roles that are being relied upon. And in this respect, I think the main question now, as you're moving maybe as a vendor from a processor to a controller role, if you are doing interesting things with data, like developing machine learning models or trying to develop AI, is whether you need your customers to help you comply with your own obligations. If you don't have the storefront through which to promote your own privacy disclosures and transparency, do you need your customer to provide their end users with your privacy notice in order to justify the use of your data, for example? All of this requires a re-examination of contractual provisions because it's rare that you can manage this compliance obligation in another way. So parties will need to consider the circumstances in which liability can and should be limited, and whether any limitations on liability in the commercial contracts are appropriate in light of the risks that are being associated with the processing. Thought should be given to things like data privacy supercaps, or if you've already got something like that, revisiting the numbers associated with such caps and the limitations on liability you already have in place.
Amazing. Thank you so much for that, Natalie. That was an incredibly helpful summary of lots of issues to think through. Look, there's so much to think about out there in the world of privacy. We hope we've kind of given you a little bit of an insight into where, or suggestion for where we think you could be usefully focusing your energies and resources. Look out for further webinars from the Phil Fisher team, the next one being on June the 8th on the NIS2 directive, which Natalie mentioned and also Pardeep mentioned. So more detail on that on the next webinar. Thanks very much, everyone.